Welcome to Self-Represented in Family Court. Your host, Tracy B. That's me. So, here we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Is to actually decide for you at any point in your case, at any point, you can decide if you want to change the course or the path of your case. What that means is actually subjective, but you can decide if you're going to negotiate and settle. You can decide if you're going to withdraw. You can decide if you're going to go to trial. You can decide if you're going to work with an attorney. You can decide if you're going to work with a coach, a strategist like me. You can decide if you're going to do this entirely pro se. You get to decide. At the end of the day, don't let anybody control or make the decision for you. You get to decide. This is your case. This is your family. This is your future. It's entirely up to you. Yes, you have control here. Absolutely, you do. Don't let anybody tell you that you give up 100% control of everything once you're in family court. That is not true. You have some control. You have to learn, though. It's entirely up to you to learn and understand where that control is and how to best use it. What you can't control, you can't control. When you realize there are things that you can't control, that there's some intransigent factors that's going to affect the overall outcome of your case, you don't expend your energy on those things because you know they're uncontrollable. You know they're not moving. They're actually stable. They're stuck. They're not going anywhere. It's not changing. So what do? You change the way you move around it. You change the way you actually incorporate those things into your game plan. You change. That's what you change. You move the other variables. You control the other variables that you have control over. And there are some that you have control over in family court. Trust me, I've been doing this 20 plus years. You have some control. Say it with me. I have some control. Yes, you do. So, as I said, there are several things you can do. I will revisit this topic repeatedly because I think it's extremely, extremely important. Every single week, at least a couple times a week, someone is reaching out to me, telling me that they've exhausted their life savings, their retirement, their kids' college funds, everything they had. They've taken out loans, they've refinanced property, they owe their parents, they owe their family, they've maxed out their credit cards, they filed bankruptcy, they are homeless now. I hear it all the time. All because they used all of those monies paying lawyers, paying legal fees, whatever. And my thing is, you don't have to. You don't have to. That's the whole point of my discussion this week. You don't have to do that. There are options. You need to know what those options are before you find yourself one of those people. But know that there are. It's no excuse. There is absolutely no excuse for you to spend $300,000 on something that could have been done with a fraction of that money, especially $300,000, and to still not have a resolution. That is entirely unacceptable. So that's it. That's what I have for this week. And my Tracy-ism for this week is, the more money you spend, the more money you'll spend. The more money you spend in the beginning, at the top, up front, the more money you'll wind up spending overall. Because if you're working with an attorney, the attorney's going to keep billing you. And the more you pay, the more they bill you. If you're working with an attorney, they may encourage you to hire guardian ad litem, to do custody evaluations, to go through discovery, those things that run up those legal fees really quickly. The more money you spend, the more money you'll spend. Just keep that in mind. If you're interested in working with me on strategy, on keeping legal costs down, on getting through the family court process without dying from stress or overwhelm, please feel free to reach out to me at Tracy at thedivorcesolutionist.com. That's Tracy, Tracey, at thedivorcesolutionist.com. Or feel free to schedule a free 15-minute phone call regarding my services at www.calendly.com/divorcecoach/ESQ/15 minutes. The link is in the show notes. For right now, I will talk to you later. Bye-bye. The next one, I believe, is number 9, or you might have gotten some bonuses in here because I lost track because there's so many. I just picked 10 off the top of my head, but there's a gazillion. The next one is, if you're not going to work with an attorney, hire an attorney, maybe you want to do some limited scope or have an attorney in an advisory role. Attorneys are doing that now. They are actually, the rules are allowing more attorneys to do that now. 20 years ago, when I was practicing, it wasn't as rampant as it is now for attorneys to do limited scope or to serve in advisory roles, but it is now. And my guess is it has a lot to do with the plethora of pro se litigants that have showed up in family court as a result of the pandemic. And other things, there's a bunch of things that happened in the last decade that, finally shifted the focus to the benefits of allowing attorneys to do a more limited scope. So there are attorneys who would do that. And they usually, those are the ones that would usually negotiate their limited scope fees. So if you want to, and I always suggest to people that they at least explore talking to a few attorneys, 2 or 3 attorneys, just to get an idea of some things that you need to know. And, a few of those things is, what your judge is like, the time span by which your court specifically addresses things like contempt or modification, any initiatives that's going on in your court, your jurisdiction, that you're not made aware of, anything as far as the judge's cycle or length of duration of presiding in family court, if they have a cycle where judges like a wheel where they go in and out, or they sit for a term and then they go to someone else, you need to know that. That's going to help you plot and plan what you do, how you do the timing of things. So an attorney in your local area is the best one to know that. And they can be really, really helpful. They're not going to represent you if you don't want to have one represent you in full capacity. You can definitely do a limited scope or have them serve in an advisory role. That is very, 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 very helpful. And then the last one, dun, dun, dun. The next one is, be organized. Be organized, be resourceful, be organized. What does that mean? That means learn how to Document properly, learn how to gather information effectively, and learn how to organize it all so that if you are going to court pro se, you're not wasting time, you're not unnecessarily delaying the process, you're not costing yourself the possibility of having to pay attorney's fees to the other party if they have attorneys, or being fined by the court. Someone just told me today that they were fined by the court for using profanity in a co-parenting app, and judges will do that. They will impose fees or sanctions against pro se litigants. So be organized, be resourceful, and be prepared. Be prepared. Be prepared enough to know what you need to know. So many people come to me and they have no clue what they're doing or what they need to do. And I get it with the confluence of emotions and worry and, trauma and a gazillion other things. It's really hard to stay focused. That's why I'm a fan of having a support system. I'm a fan of people having someone, one person that is good at paying attention to, when they go to court, what's going on with the judge, what's going on with the other party. They're good at when, exchanges are made with the kids, at paying attention to surroundings. They're good at taking notes. They're good at taking photos. They're good at taking videos. They're good at they'd be an excellent witness if necessary. I am a huge fan of people having that one person, maybe two, that they can count on to be their second set of eyes and ears on a day-to-day basis. And it's unfortunate that you have to do this, but you have to do this. It is what it is. So learn how to document. So many people think that they know how to document and they don't. They don't have a clue. And then when they do, excuse me, they're not understanding that what they're documenting is not necessarily helpful, or they're documenting things that are irrelevant, and they're missing the most important things because, who knows why. Or more importantly, they're not organizing it properly. I get people who come to me and they have so much information, but they documented it or they organized it incorrectly, and they've gone to court, they've taken a chance to go to court, or they turned it over in discovery to the other party, and it actually, it didn't help. It actually set them back a bit. So it's important to know how to document, and that's an entirely different episode as well. How to document, how to organize, how to present, how to be prepared. That's extremely, extremely important, and it's extremely time saving and actually money saving as well. The other thing is know your judge. Know your judge, know your judge, know your judge. Knowing your judge is important because that is the way you'll know what you need to do when you need to do it. If you're thinking about filing contempt and you don't know if you should file contempt, because not only is it going to take up time and time away from work, time away from your kids and your family, it can actually cost you. Because sometimes if you file contempt and the judge finds that there was no contempt and the other party asks for attorney's fees, that they had to hire an attorney, the judge can make you pay attorney's fees. And who wants to pay somebody else's attorney's fees? Not you. So knowing if your judge is actually going to do anything about contempt or not is extremely important. It's very important. Knowing when or if you should file contempt should rely a lot on the court order and your specific judge. Those two things should be at the top of your list, and then everything else should fall after that. But knowing your judge is extremely, extremely valuable or invaluable. It's priceless. It actually should be number 2 after me being number 1 on this list. But this is in no order, no particular order. It's just as I think as it comes to my head. Well, hello there. It's me, Tracy B, and you're listening to Self Represented in Family Court. I am the divorce solutionist, the family court strategist, the mediator, the parent coordinator, the podcaster, the author, the writer, the public speaker. But my most impactful role is as a strategist. Yes, a strategist. I am able to save people so much time and so much money working with them on strategy. So, guess what today's topic is? 10 things you can do to avoid wasting your life savings on legal fees. And what tops that list? Working with me, Tracy B. Yes, because as a strategist, I'm able to employ so many different tactics and methods and means and ways to help you accomplish your goals. You do have a goal, right? You should have a case goal or some case goals. You should not be going to family court flying blindly. Please do not do that. Have a specific plan in mind. And what that plan is entirely up to you. Nobody else but you. You need to take some time, spend some time working on a plan that's going to work and fit your lifestyle, your circumstances, your budget, your physical and mental and emotional well-being. It needs to fit exactly what is going to help you accomplish your goals based on where you are and what you have access to. And that's what I do as a strategist. I am trained in so many areas that overlap into actually what it takes to come up with strategy. It takes critical thinking skills, problem solving skills, communication skills. I mean, it runs the gamut. And I actually regularly train. I take trainings, I take courses, I take certifications to make sure my skills are up to par as a strategist. I didn't do that as an attorney. I do it now. And because I do that, I am much more effective with helping my clients create a strategy, create a game plan that is not a cookie cutter, that is not one size fits all, that is not something that I did for 10 other clients. I work with my clients one to one based on who they are, who their judge is, who the opposing counsel is, the other party is, who the guardian ad litem is, the jurisdiction they're in. I mean, it literally narrows down to which law enforcement is closest to them, because we want to know if we ever needed to use law enforcement, what their protocol is. So as a strategist, yeah, I can literally save you easily $20,000 on average just on working with you on your strategy, on your game plan. So that tops my list of things to do to avoid wasting your life savings on legal fees. Number 2, you can start your case as pro se. Yes, you can. In most jurisdictions, in every 50 state, there is some means, some method to get you started as pro se. Granted, there are some places that are better than others when it comes to helping you get your foot in the door as pro se. I believe Tennessee has one of the worst pro se resources available. And then on the opposite end of that spectrum, Florida happens to be one of the best. They have one of the best pro se resource, the statewide. Of course, things vary from county to county, but Florida and California happens to be really good with offering resources for pro se litigants. So you don't have to remain pro se. You can start your case. You can save on average, especially if you're going through a high conflict divorce. You can save yourself on average $8,000 to $10,000 just by starting your case on your own. And at any point you feel necessary, for whatever reason, to hire an attorney, you can do that. But get the case started on your own. You can find resources, instructions, videos, books, podcasts like mine, courses, right In 2025, there is absolutely no excuse why anybody should not be able to find what they need to get their case started on their own. What it entails is starting with going to your court's website to see what's there. If there's not much there, see if there is legal services or legal aid in your area, a law school, clinic, or just any sort of organization that helps pro se litigants get started. In New Jersey, it is the Legal Services Office that sells packets for pro se litigants to get their divorce started. They sell them for $25. And it's the entire packet. Every form you need, they sell it. It's $25. In some states, they may not have all the forms, but they have some of them. But there's no excuse. There's no excuse. You can start your divorce. You can start your custody. You can start your contempt. You can start your relocation. You can get it started on your own. I see so many people think that they have to go to an attorney and spend $5,000 to $10,000 as the initial retainer. As the initial retainer, not the full price for the case, the initial retainer. And that is when they find that they waste the most money, because in the beginning stages, not much happens. It's really just the lawyer going back and forth, doing filings, doing document preparation, and that's it. And they can easily exhaust $75,000 to $10,000 just doing that. You haven't even gone to court and you're already exhausted. Anywhere between $7,500 and $10,000. Nope, save that money and do it yourself. And then when you are going to your first court appearance or your first mediation does require an attorney, but if you want an attorney to go with you to mediation, or when your first court appearance comes up and you feel the need to hire an attorney, then you can do that then. But if you are, if you have even a 5th grade education, and I'm not being facetious, I'm serious. If you have even a 5th grade education, there's no excuse. You can definitely get your case started on your own. That's number 2. Number 3, if you do plan on hiring an attorney, do not go to any attorney with the look of desperation or the look of fear. Attorneys are sharks. They smell blood in the water when you come to them and you're desperate and you're terrified and you're mortified and you're angry. Any riled up emotion or desperation, they are going to pounce on you. There's some who won't, but a lot of attorneys are going to take advantage of that. They are sharks. They will smell blood in the water. They will smell that blood when you walk into their office. Do not go to attorneys ready to pay initial retainer fees. Try to negotiate them. Ask them questions. Make sure you understand what it covers. Make sure they give you an idea, which is almost impossible, but still ask how much on average would a case like yours cost. Ask them, is there anything that you can possibly do on your own before you go and give them that initial retainer. Just try to have a conversation about the initial deposit, as opposed to just going to them with your checkbook in hand and ready to sign your money over. You know why? Because just like they smell blood in the water when you're in fear and desperation, they smell blood in the water when you're coming with a checkbook ready to sign, ready to send money over. So please do your homework, do your research, find a good attorney, ask questions, and make sure you calm down. Make sure you have somebody to go with you. Yes, take somebody with you to meet with attorneys. Absolutely, that's an excellent idea. Someone who's sound, who's attentive, who is very, very astute with asking questions and paying attention. Yes, it's extremely important to do that. Number 3, do your own research. I can't tell you how many people who come to me, their case is almost demolished, destroyed, because they did not do their research. Their idea of research is going on social media, asking questions from other people who are not attorneys, taking their advice, and actually implementing and executing on exactly what they say to do. There is no one size fits all, people. There is no one size fits all in family court. There is none. Every single case is going to be handled differently because there's so many variables. I can't stress that enough. Your case is not like the person who has the same circumstances. They don't have the same judge. They don't have the same lawyers. You're not like any of those other parties, nor is the other party like any of those other parties. They don't have the same temperament. They don't have the same resources. They don't have the same acumen. No two cases are alike. Your case is your case. Do your own research. Yes, of course, ask questions, but figure out how that employs or how that should be implemented in your overall game plan, your overall strategy, right? Do your research, read, listen to podcasts like mine, watch videos, read blogs. I mean, there's a plethora of information out there now. That's number 3. Number 4 is do not jump at the opportunity to hire a guardian ad litem or to ask the court for a guardian ad litem. Guardian ad litems are not inexpensive. They can be very expensive. And if you have an attorney that you're already, paying $20,000, you can easily tack on another $10,000 to $20,000 in guardian ad litem fees. So do not go to court immediately asking for a guardian ad litem. Guardian ad litems can be extremely helpful in some cases, but they're not the most cost-efficient way to accomplish the goal you're trying to accomplish by hiring them or asking for that one be assigned. Guardian ad litems, I honestly believe guardian ad litems can be extremely helpful in relaying third-party communication for your child to the court. I think that's one of the best ways to do that, but it's not the only way. There are other ways to do that, and that's another topic for another day. But please, some people think they're supposed to just go to court and just instantly ask for a guardian ad litem, and it's just not the best way to do it. What's the best thing for you to do? The best route for you to accomplish the same goal? I can't answer that without actually having a conversation with you. But just know that is not always the most cost-efficient way. And the next one is the same thing with custody evaluations. Custody evaluations are not necessarily the most cost-effective ways to accomplish your goals either. You should definitely seek out other alternatives. If your child is in therapy, you could talk to their therapist and ask them if they'd be willing to come to court and testify or submit records to the court directly if the judge is amenable to that. But you should certainly, custody evaluations as well can be very expensive. They can be very, very expensive. And sometimes they're not even worth their weight, honestly. Sometimes there's so many flaws with custody. That's another topic for another episode as well. But there can be so many flaws with custody evaluations that sometimes it's just not the best route to go. The number 5 is mediation. I hear so many people tell me that the other party would never consent to mediation, or they don't want to do mediation because they know it's going to be a waste of time. There's so many things. But believe it or not, mediation can actually be so cost-effective way to keep those legal fees down. Mediation can be extremely helpful, even if you don't resolve it in mediation. Sometimes having that discussion in mediation helps for future negotiations. So, because you have a skill, hopefully you know how to vet mediators if you have an option. Some courts, you don't have an option, you're assigned a mediator, but you can actually do private mediation as well. You don't have to. In most cases, you can bypass the court-appointed mediator and do private mediation instead, because the court is always going to want you to resolve your case. The court is always going to want to see you settle your case. So if your case is started in court and you decide to do private mediation, after that, that's fine. If you get an agreement as a result of that, then you submit that, and it pretty much, is done. The court doesn't really care. If you don't go to court and you want to do private mediation, same thing. You get a mediated agreement, you submit it to the court, it's done. If your case is started and there's mandated mediation and the court has its own roster, like New Jersey does, I believe you can still, in some jurisdictions, you can still waive the court-appointed mediator, and if both of you agree, you can still use a private mediator. I suggest that you go to mediation without an attorney. You don't need an attorney. I'm being really honest. You don't have to pay an attorney to go to mediation. And some attorneys are decent enough to tell you that. If you feel more comfortable having an attorney with you, that's fine. But in most cases, they're not able to talk too much anyway in mediation. So sometimes they're not really that helpful. They can help you prepare for mediation, which you don't really need an attorney to help you prepare for mediation. There's so many resources out there to help you prepare for mediation. I actually work with people on mediation. I actually do mediation, co-parenting mediation and custody mediation and divorce mediation. But I also prep people for those as well. I actually prepare people for their actual mediation. So we'll do a strategy session just on preparing for mediation. That's certainly an option. We can certainly do that. And that, again, that's a cost-effective way of, not paying an attorney $500 an hour to meet with you just to prepare you for mediation, or $500 an hour on top of what you have to pay the mediator for the attorney to attend mediation with you. Try mediation. Try mediation before you do anything else. See if the other party is amenable to it, and be open-minded about it. And if it doesn't work, all is not lost. Trust me, you've gained some skills from mediation. You've gained something you should have. There's so many benefits to actually being in person with the other party and a neutral third party, and hearing things from a different perspective, especially when you didn't do that prior. So that's number 5, I believe. And then the next one is number 6. The next one is, if you get any kind of government assistance, you can certainly see what you're eligible for. Sometimes receiving government assistance will allow you fee waivers. That means filing fee waivers. In some jurisdictions, it allows you to receive free legal representation, free legal resources like forms. If some forms have a fee, you may be able to get the forms for free. I believe I've ran into an instance where even getting the audio recording, because transcripts are usually charged by private entities. But if a court records any sort of court appearance, sometimes you're entitled to those minutes, not the minutes, I keep saying that, the actual recording, because the court produces the recording for free. Find out what the fee waiver program is in your area and see how far it goes. See how far it goes. That's definitely one way to help you keep the costs down. Another way is to try to settle on your own. Try to settle. Do a cost benefits analysis. And I actually have a worksheet that I use with my clients where you are actually able to go through everything tangible and intangible that a custody or divorce or modification or contempt would cost you, and to see if the benefits outweigh the costs. That is one sure way to keep those legal fees down. Because if you're one of those people who insist on hiring an attorney, you may want to consider whether you should even go to court. You may want to see if there's another way to resolve the case, the issue with the other party. Whatever that may be, a trade-off, foregoing something because it's just not, worth it. Whatever it is, but do a cost-benefit analysis. Try settling on your own. At least try. Not to mention, it serves so many purposes to try to reach out to the other party to see if you can negotiate a settlement. It doesn't matter who started the case or who's thinking about going to court. If you can try to resolve things and you go to court and show the judge that you actually try to resolve the issue that you're actually in front of the judge for, that's one way to get huge brownie points from the court, honestly, because the courts do not want you there. And any attempts to resolve the case, good faith attempts, not just BS attempts just to, placate yourself or the other party or the judge or any other person, but good faith attempts, meaning they, they sound reasonable, they don't sound outlandish, they don't sound, improbable. They're really good faith attempts where you really, really, tried and made an effort to resolve the case without going to court. That's always a huge brownie point for you in any court that you're in. I want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.